I'm Keith Becker, the General Manager of Deedee's. AB 1482 is now law in California, and it's very complicated, but it can be broken out into 5 major subject matters. Today, we're going to discuss at-fault evictions as one of the just cause components of the Tenant Protection Act of 2019. Before we go too far, I do want to explain that we are so very early into this process that the ideas, the best practices that we have now may change over time as we get a better understanding of how AB 1482 works, as the law tightens it up, as case law establishes what is and is not best practice. So this is our best recommendations right now. Furthermore, each and every situation is unique. If you have legal questions, please contact your attorney. From the top, as an overview, AB 1482 is indeed a rent control ordinance law. It limits rent increases to no more than 5% plus CPI, with an absolute cap of no more than 10%. It limits the reasons why an applicable property, the housing provider might request or require a tenant to vacate the property, and in some instances, it requires that the landlord, the owner, provide to the tenant relocation costs in those instances when the tenant vacates. If you have a property that is has to be compliant with AB 1482 because it is not exempt, your contract must include this verbiage, specifically written this way using these words, and it must be in your contract in no less than 12-point font. There is a deadline specific for this. New contracts and renewing leases, it must be in effect by July 1st of the year 2020. If you have a month-to-month tenancy, it must be written in no later than August 1st of the same year. So, if you've got a property that is not exempt, how do you get the property back? There are 2 reasons and 2 major categories by which and why you might be permitted to get the property back. There is the concept of at-fault just cause, which is tenant behavior issues, and then there is no-fault just cause, which is a limited number of reasons why an owner might unilaterally be permitted to decide that they want the property back. Both are very short lists. Let's go through the list of at-fault tenant behavioral issues whereby you as the landlord might be permitted to take the property back. One reason is if you have a tenant and the tenant's on a lease and you offer them a new lease with fundamentally the same terms and they refuse to sign a new lease. That is a justified at-fault reason to terminate tenancy. In addition, and these 2, the employee agent licensee fails to vacate after their termination as an employee. Let's imagine you've got a multi-unit building. The multi-unit building requires an on-site manager. If your on-site manager has been terminated, their tenancy terminates. Actually, on-site manager, it's not even classified as tenancy, but this is written in to make sure that on-site managers must leave when their employment terminates. If the tenant gives you notice that they're going to vacate, and they do not do so on the date that they say they're going to, that is a reason for an at-fault just cause eviction. If they don't pay the rent, of course, you gotta pay to stay. If you don't pay the rent, that's an at-fault reason. The tenant's refusal to allow the owner to gain access to the property with the proper advance notice under the proper reasons. If they fail to allow you access, that is a reason for you to say, you know what, if you're not going to allow me access to the property that you reside in, yes, but I own and I am obligated to know the condition of. If you're not going to allow me access, you must leave. Any criminal activity or threat, whether or not it's actually on the premises or somewhere else. If the threat is against the property owner or the property manager, the property manager walks into the tenant walks into a property manager's office or shows up at the owner's door and basically says something that is aggressive, violent, threatening, that is a reason to vacate the tenant as an at-fault just cause reason. Committing waste. Now, committing waste as it is legally described does not mean leaving trash in the yard. Committing waste is damage to the property that is serious and significant enough that it will diminish the value of the property. So let's just say, for example, the tenant vandalizes the garage and it's a sheetrock garage and they start taking drywall off the walls of the garage. That qualifies as committing waste. It's a reason at fault, just cause, bye-bye. The following reasons are reasons within AB 1482, but I put an asterisk after each. A breach in the material term of the rental contract itself. Something that is written into the contract that the tenant is not abiding by. Criminal activity by the tenant on the residential property, including in any property in any common areas. Using the premises for an unlawful purpose. They're dealing drugs out of the property, unlawful purpose. Assigning or subletting the premises in violation of the tenant's rental contract. You must have it written into your rental contract to state that the tenant cannot, in order basically allow this term to actually be in effect. Maintaining, committing, or permitting the maintenance or commission of a nuisance. Parties every Friday night is gonna upset the neighbors. That's a nuisance. Now, the fact is that those asterisk issues are frequently very difficult to prove. It's necessary to document clearly and consistently and repeatedly when you have indications that these are violations, that these are possible at-fault reasons why a tenant might be required to vacate. The problem is, however, that many times the housing provider does not have first-hand information on the behavior that is actually occurring. They're hearing it from adjacent residents of their own. They're hearing it from neighbors. They're hearing it from third parties. And in instances where you have to prove these types of behaviors, it is entirely possible that you would be required to draw in those adjacent neighbors, those third parties, into what could conceivably be as much as a court case to declare witness for the bad behavior that's happening. This is one of the more problematic aspects of AB 1482 or any rent control law that includes a just cause eviction component. In order to make sure that you are removing a tenant properly under an at-fault just cause process, you have to make sure that you properly serve, and in most instances, you have to give them a 3-day notice to cure. I say most instances, but it's not all. A 3-day notice to cure. For example, the tenants who are having the parties every Friday night, you must give them a 3-day notice to cure, saying, no later than 3 days from now and going forward from that point, you must abide by your contract and no longer be performing this nuisance. If it happens again at the expiration of that 3-day period, then you are permitted to serve a 3-day notice to quit. At that point, it is considered to be an incurable breach of the contract, and they can't come back at that point and say, wait, we promise we'll not do this ever again. It actually is, you have a chance to cure it, and if you do not permanently thereafter cure it, then the 3-day notice to quit comes down like a hammer. At that point, after that point, you can commence eviction proceedings. There are some instances and some behaviors that do not require a 3-day notice to cure. The subletting, the criminal activity, certain behaviors are still egregious enough that a 3-day notice to quit could conceivably be applicable. In those instances, however, you do want to speak with your attorney. Just cause applies specifically under AB 1482. There's one sort of protection here. Just cause applies only if all tenants on the original contract have continuously and lawfully occupied the property for at least 12 months, or if it's a situation where a couple of them have come and gone, if at least one of the original tenants has resided in the property for at least 24 months. Now, continuous occupancy for 12 months. What that means is if you have a tenant who moves in and they sign a 1-year lease at the time that they move in, and the continuous occupancy goes into effect 12 months later, theoretically, you have tenants who could conceivably be legally protected as life estate tenants from day one. So, it's entirely possible for properties that are under AB 1482 where it does apply, that fixed term leases will fall into disfavor because the first 12 months may very well be considered to be a probationary period for those tenants to make sure that as the housing provider, you want to ensure that you want to have a long-term relationship with that resident. Because once they have the protections, the decision to vacate, with very few exceptions, is in their hands, not the housing providers. Please feel free. This is complicated stuff. If you have questions, contact a real estate agent, contact a property management professional. We'd be glad to help. And as I said before, I'm not an attorney. If you've got legal questions, please contact an attorney. I'm Keith Becker from Dedes.